Yes.
Well, hello, everyone. Good afternoon. Welcome to our Sealaska Heritage Fall Lecture Series. Thanks for joining today. My name is David Russell Jensen. My Tlingit name is Shakaguk. I serve here at Sealaska Heritage as our development officer. I'm pleased to welcome you to today's lecture. Today is one of several free lectures over the next few months. You can review the full fall lecture series at sealaskaheritage.org. Sealaska Heritage is committed to providing accessible community programming, but it wouldn't be possible without the support of donations. You can contribute in person via the donation envelopes at your chairs or online at sealaskaheritage.org/donate. Today's lecture is on the upcoming Constitutional Convention question and is presented by Bruce Botelho. Botelho retired after completing 4 terms as mayor of Juneau, which I understand is our longest serving mayor in Juneau's history. He has also served in various capacities with the state of Alaska, ultimately as Attorney General of the Alaska Department of Law. Botelho is married to Lupita Alvarez, and they have 2 children, Alejandro and Adriana. On November 8th, Alaskans will once again be asked to answer the question, shall there be a constitutional convention? There will be an opportunity for question and answer at the end of our lecture. If you're here in person, we have a microphone for you, or you can enter questions online. Please welcome Bruce Botelho. Thanks.
Thank you. The first thing I have to do is start my stopwatch. I trust somebody else will stop me if I go well beyond 2 o'clock. The question that will appear is exactly as framed in the slide. Shall there be a constitutional convention? What I want to do today is provide a little perspective, a historical context for that question, going into the earliest efforts towards Alaska statehood. And I think I've just lost my screen. Little technical glitch here. The point that I will be making right here is that the convention was simply a means towards statehood at its inception, but particularly for the delegates, it became an end in itself. All of it was triggered by the framework of our national founders, and that is that it would be up to Congress to decide what conditions would be imposed on any territory seeking to become part of the United States. And there was a fairly well trodden path towards that statehood. In almost all situations, not all, the formulation was a petition from the territorial government asking that it be considered for statehood. The term formally is called a memorial. And then there would be a passage of federal legislation that would authorize the constitutional convention and would also set forth all the different requirements that Congress would expect from that state, and most importantly, what needed to be in that constitution. There would be the call, convention would be held, there would be a vote of the people in the territory, and as noted, seen here, those results forwarded to the president approving it, and then ultimately the election of officers. Well, the speed bump for Alaska, a 15-year speed bump, was number 2, passage of an enabling act. Now, the first effort towards seeking statehood was a result of legislation which our non-voting delegate, James Wickersham, had introduced in 1916. It didn't go anywhere, and I suspect he himself did not expect it to do so, but in no small part because of the war in Europe and the likely entry of the U.S. itself in the coming year dampened any interest in looking at statehood. The next time it appears on anybody's screen is 1943, and it's not happening here in Juneau or in the territory. It's happening 1,500 miles away in Carson City. The Assembly and Senate of Nevada developed a memorial calling for Alaska's admission to the Union. That passed in early March of 1943. And the delegates from the Nevada legislature went to a Western states legislative meeting and was able to get that assembly to adopt a resolution as well. And as a consequence of that, Pat McCarran, who was Democratic senator from Nevada, along with William Langer of North Dakota, introduced a bill in Congress calling for Alaska statehood. And now for a little side story here. In 1932, a young couple, he a journalist and she a social worker in Illinois, they met and married. They end up moving to Worcester, Massachusetts. And in for him to take over the publishing of a small newspaper. And in 1945, his father-in-law, or I'm sorry, 1935, his father-in-law said, there's a newspaper where I live, and I'm willing to join you in buying it if you're willing to move to Alaska, and in particular in Anchorage. Now, who were these people? The father-in-law was Ed Rasmussen, and it was his daughter, Evangeline, who had married Bob Atwood. And so in 1935, Bob Atwood, at that time 28 years old, they move and resettle in Anchorage. And over the course of the next 8 years, he becomes one of the leading citizens of Anchorage. The Anchorage Times is one of the two most influential newspapers in the territory, and he, by that time, had been president of the Chamber of Commerce. And, of course, someone who paid intense attention to national news. It caught his eye that Langer and McCarran had introduced this bill, and he could find no one in Alaska who could explain why or who had prompted this legislation. He was particularly suspicious of Pat McCarran because McCarran had been very unsympathetic to Alaska in other respects. But he decided he'd write a letter to both of them and ask them, why did you support this bill? Well, McCarran, not surprisingly, sent back a form letter acknowledging receipt of Atwood's letter, and that was about it. But Langer writes a 3-page letter explaining all the reasons he thinks Alaska should be admitted to statehood. And Atwood is so taken by the letter that he decided that statehood was going to be his life's mission. And as a consequence of that, the editorial policy immediately of the Anchorage Times was to call for immediate statehood. Evangeline, for her part, takes up the cause as well, organizes what's called the Alaska Statehood Association. She forms 10 chapters around Alaska to push, and primarily women, to push for Alaska statehood. The consequence of which was in 1945, the legislature, having been bombarded from various sources, first delivers a memorial to Congress calling for Alaska statehood. And the second thing they do is call for a referendum, an advisory vote in essence, about whether Alaska should become a state or not, and places it on the ballot for the October 1946 general election. Now, first of all, what you're seeing here on the screen is the memorial that Nevada sent to Congress asking for Alaska statehood. And you'll notice that there's a name, Mr. Phillips. Fred Phillips is the person who actually introduced the resolution. There is no record of any committee hearings. There's no transcript of any of the debate that took place in either the Assembly or the Senate. And there's precious little information on Mr. Phillips himself. He actually was a Russian immigrant. His family, he was born in 1882, moved with his family to the US, ended up in Chicago. He is still with his father in Chicago in 1905, but in 1906, he decides to join the Army, and he changes his name to Fred Phillips. And the next time he appears is in the teens in San Francisco. He's working as a furrier for the Hudson's Bay Fur Company. And he gets married, ends up moving to Reno, Nevada, at some point becomes a dentist, and then is elected first in 1934 to the Nevada Assembly, and serves again 2 terms, and again serves out from 1940 to 1945 when he dies. So when we look at Alaska history and the things that moved us towards statehood, we have a stranger from Nevada to explain the trigger of a 15-year fight to get statehood. Now, and this is the bill that was introduced by Langer and McCarran. It authorizes a vote. It calls for a 17-member delegation at the convention, 1 to be elected at large, 4 each from the 4 judicial districts of the territory, that it would take place in Juneau, and that it not last more than 60 days. It also had the typical language that one finds in such bills, requiring that we promise to have a government Republican in nature, and that we observe all the rights that are guaranteed by the Constitution and Declaration of Independence. I should say one other thing here. In the bill that both Langer and McCarran introduced, motivated Anthony Diamond, who was Alaska's non-voting delegate in 1943, to actually introduce a companion bill that was identical to that which they had introduced. Diamond had been elected in 1933, and so he actually in 32, and had served beginning in 1933. And so he had been silent on this issue for 10 years, and actually I think was more or less compelled by the efforts by Langer and McCarran. Diamond himself had been mayor of Valdez immediately before being elected in 1933. Interestingly, he was also the godfather of Bill Egan, and his chief staffer in his final 2 years in Congress was E.L. Bob Bartlett, who went on then to be elected the next non-voting delegate from Alaska. So the vote takes place in 1946. It's a 3-2 vote in favor of statehood. The other significant event of that year was that President Truman, for the first of his 4 State of the Union addresses, actually calls for the admission of both Hawaii and Alaska. He does it then 3 successive years following that, to very little avail. Bartlett himself introduces a bill, and we see actually several other bills that get introduced over the course of the next several years, most of them originating in the House. The long and short of it is that there isn't much movement in the first couple years, not surprisingly, but in 1949, for the territory, and again, another little side issue is that territorial legislature, which consisted of a House of 24 members and a Senate of 16 members at the time, regularly swung extremely one way or the other every 2 years. And so in 1948, Democrats largely take over the legislature, and their mission is to, again, promote statehood. They form the Alaska Statehood Committee to be distinguished from the Alaska Statehood Association, but also name Bob Atwood to chair it with a charge to prepare for statehood. Their mission was to do whatever it took, and it also included within their portfolio preparing for a constitutional convention should it happen. And there was a parallel organization that developed, a grassroots organization simply called Operation Alaska, and again, its goal was in framing of the time an opportunity for the little people to speak. Without going in great detail, it is fair to say that Alaska statehood became a bit of a political football. You have examples where either the Senate has been willing to move forward or the House, but never a point where both of them could converge on legislation. What particularly dampened progress ultimately was when President Eisenhower, who was elected in 1952, and again brought in an entire sweep of the territorial legislature again. So, for example, the territorial House consisted of 20 Republicans and 4 Democrats. That'll be important in a moment. He came out and called for admission of Hawaii, but said Alaska wasn't ready. And that had an incredible chilling effect within the territory. Of course, and the message more broadly was that legislation, there would be no reason then for legislation to particularly move. Now, there were a lot of forces against territorial or statehood status for Alaska. Those were prompted by, among other things, Southern Democrats who were concerned that if Alaska were admitted, it would change the balance in the Senate on issues of civil rights. You had conservative Republicans that were concerned that Alaska would likely be a democratic state. And at the time, the US Senate was split nearly like it is today, and that would change the balance of power. You had Alaska serving as one of the forward operating bases, staging areas for the Korean War. And the Pentagon was opposed to seeing Alaska statehood, viewing it as just another bureaucracy that would take place. And then you had also what we would call outside commercial interests, the fishing industry, the resource development folks who largely opposed the idea of Alaska being able to regulate its own resources. And all of that together made clear that Alaska statehood probably was beyond reach for some indeterminate period of time. Now, that led to a boiling over in certain circles. And for the first time, there's a bill introduced in the territorial legislature calling for a constitutional convention. It said, let's not wait for Congress to enact enabling legislation for statehood. Let's just charge ahead. Hawaii, by the way, had done this in 1950 to not much more success. This bill, introduced by Warren Taylor, who was the House Minority Leader, couldn't even get a committee hearing on the bill. And that was not a reflection simply that Republicans were opposed to a convention. It was the fact that not only did no one see a prospect of moving this forward, it was a concern that if we did this, it would further antagonize forces in Washington, D.C. against Alaska statehood. And the Alaska Statehood Committee itself had urged the legislature not to move forward. 1954, Democrats take over the territorial legislature. And one of their main themes is Alaska statehood. And they convene in Fairbanks ahead of time, that is the Democratic delegates, and they agree that their primary mission, their number one goal, was a constitutional convention. And at this point, Warren Taylor, who had been the minority leader, is now Speaker of the House. And their bill, introduced at the beginning of the territorial session, called for a formulation that ultimately prevailed in calling for 55 delegates to be convened at the convention, provided for apportionment of it, limited it to 60 days, but called for it to be in the capital. As the Senate and House organized that year, Tom Stewart was selected to be the chair of the House State and Federal Affairs Committee, and Bill Egan was the corresponding chair in the Senate, and they decided to merge their efforts. The result of it was what became Chapter 46 of the Session Laws of Alaska in 1955. 55 delegates, 7 would be elected at large, 15 would come from single-member districts, and here the concern was that if we simply relied on voting from the 4 judicial divisions, all the people who would show up would be coming from the urban areas. And this effort was a way to make sure that the convention was somewhat more representative of the entire territory. Special election, date set for the convention, a limit now on 75 days, and probably most significantly the decision not to allow the convention to take place in Juneau, but instead to occur at College, Alaska. So the result of all of this long history is that the Constitution then calls for and brings us to the question of shall there be a convention, is that there are 2 ways to change it generally. One is by amendment, which can be achieved by a 2/3 vote of each house, ultimately then approval by a majority vote of the public, or by convention. Now, the convention can either be called by the legislature, which it has never done, or by the process that we are encountering on November 8th. And that is, again, convention has the authority to fully make whatever changes, rewrites it wishes, but again, subject to a vote of the people. The specific language in the Constitution that provides for this is, again, if the question has not come up anytime within the last 10 years, the lieutenant governor is required to place the question on the ballot, shall there be a constitutional convention? We're one of 14 states that has this particular feature. They vary in range from as short as 7 years to 20 years before the question comes up. And as I note here, the last 2 states to actually hold convention as a result of a vote are Hawaii in 1978 and Rhode Island in 1986. Hawaii also had the question come up in 1968, and it was approved then as well. And that was triggered largely by wanting to sort out the question of reapportionment. They ended up making some 22 different changes to their constitution. Alaskans have, since 1972, rejected it overwhelmingly each time it's come up. In almost a 2-to-1 margin over these last 5 times. I postulate, though, that I think this year is a different year. And I think, again, I identify 3 factors on it. First of all, I think there's a general national climate of distrust. I use the word disaffection with governmental institutions, a feeling that the country is in a wrong place. And I would say that this attitude increasingly permeates a lot of Alaska's politics today as well. I think probably most visibly in activities we've seen in dealing with COVID and some of the extreme reactions we saw in the Anchorage Assembly in particular. Second has been a series of proposals which the governor has made, knowing that they had no chance in the legislature. They're very populist ideas, and they've just not had traction there, but are issues that, if played to the crowd, could very well propel an affirmative vote on it. And finally, and parallel to that, is there is now an active, organized effort to garner support for a convention. The governor's issues, and I don't go into some of his attacks on the judiciary, but he's had specific constitutional amendments which he has proposed that I think are ones that would garner support, but have not been able to get the requisite 2/3 vote in each house of the legislature. And for him, their failure to move on this legislation is simply proof certain that the legislature doesn't work. The first is a constitutional spending limit. Alaska already does have a constitutional provision limiting government spending. The argument is this doesn't work. That may be in part true. The second has been, and probably I think the most dynamic in terms of the risk, is wanting to embed the permanent fund dividend into the Constitution and provide for a specific payout that would have priority over other payout. And the third populist idea has been the view that the public should be given the right to vote to approve any new taxes before they may be, general taxes before they may be instituted by the legislature. I mentioned that there is an organized group that is promoting the convention. The group is called Convention Yes. And there's just a couple of shots from their website. I have highlighted in yellow the messages that stand out to me: claim of corruption in government, the theft of the permanent fund dividend, which again gets back to embedding it in the Constitution, and judicial overreach, which has usually been coded primarily over the issue of right to choose, or abortion generally. And then the message that again corresponds, I think, with the governor's focus on the inability of the legislature to reach agreement on his proposed amendments, ineffective legislature. There are a lot of themes that have been coming out in support of the convention. I've highlighted here what I see as the 5 major themes: PFD, prohibition on abortion. There are a lot of different ways. Change the judiciary, the spending limits, and a theme that has particularly percolated, I think, in the last year has been in terms of parental rights, school choice, vouchers in particular, and control over curriculum. I mention this as not to suggest that all of these are appropriate for constitutional amendments, but these are themes being argued for why we need one. And secondary ones, I have one listed here as secondary, but for us here in Juneau, in Southeast, I would say probably a major concern for us is relocating the state capital. But again, I note the initiative, right to work, the efforts to narrow other protections, among others. So what happens if it passes? The Constitution provides that unless there's been any other provision by law, which is to read, unless the legislature has provided for something else, we will follow the dictates or the parameters that guided the 1955 convention. And that would be, as you note here, including but not limited to the members' districts, certification, submission and ratification of changes. Now, you may not have noted, I have not said that it's been defeated every time the question has come up. It actually passed in 1970. It barely passed, but it did pass. And the result of that election in 1970 also brought Bill Egan to his second term, actually his third term as governor. He'd had an abbreviated one. As a result of that, he immediately had introduced legislation in the 1971 session to prepare for a convention. And the formulation that he and his staff submitted to the legislature called for 65 delegates, 5 of whom would be elected at large, and the rest of them based on their corresponding House and Senate districts. Called for a 75-day session. His proposal called for it to take place in college. The bill started moving through committee, and very quickly, the first change that took place was to move the convention to Anchorage. And it called for creation of an Alaska Constitutional Convention Commission that would be dominated by the governor, basically to serve in preparation for the convention. But it was also this body that would ultimately decide which part of Anchorage this convention would take place in. In the meantime, there had been a challenge to the outcome of that election. The question had been framed as required by the Alaska Constitution: shall there be a constitutional convention? And citizens challenged the language as being misleading. Av Gross and I'm blanking out on Jim Bradley, thank you. Thank you, Jim. Brought the case challenging the decision, and the Superior Court judge, Vic Carlson, concluded that it was in fact misleading. It was appealed to the Supreme Court, and the Supreme Court affirmed the trial court's conclusion that it was in fact misleading and directed that it be placed on the next ballot. And that took place then in 1972, and we've seen the results since then. The issue of what the convention should look like arose again in 1978. There was some question about whether the schedule should bring this back to the initial sequencing, which is 1970, 1980. And so between 1978 and 1980, the legislature again wrestled with the question of what should happen at the convention, what should it look like. And again, a joint committee formulated this particular model, which in many respects conforms to that which Governor Egan had suggested, a 65-member convention, 5 of whom would be elected at large, the remainder apportioned corresponding with House and Senate districts. That it take place no more than 90 days, it once again shows up in College, Alaska, and creates a commission. But this time, you'll note that there's been a little more influence on the legislative side to make sure that the legislative branch had greater control over what would take place. The legislation did not need to move because the outcome, again, had been an overwhelming rejection. But what we do know is that if people vote in favor of the convention, the legislature is going to be able to make and shape what takes place. That question will be where it takes place, when and for how long, how the delegates will be selected and funded, location of the call. And these, of course, are my own assumptions about it. People may dispute, but I believe that most likely location for the convention will probably be Anchorage. In any legislation that moves through, there'll be some push for the Mat-Su. I do not believe Fairbanks and Juneau will be much in contention. The timing. I think it is highly likely that the convention would have to take place in the second half of an odd year, and there are a couple reasons for that. Legislators will want to be delegates. This issue arose in 1955. Burke Riley, who at the time was representing Haines in the territorial legislature, filed to be a delegate. And there was a challenge about whether that constituted dual office holding. And the district court concluded that it was, whereupon Bartlett immediately got legislation in Congress through that determined that that would not constitute a conflict of interest. Well, of course, that was, and what happened, again, we had 14 sitting territorial legislators then who ran for delegate seats for the convention, 9 of whom were elected. And they made sure that this Constitution would make clear that there was no conflict if a legislator wished to run for the legislation, for the convention. Which is to say, they're not going to convene a convention during the first half of the year because that's when the legislature meets. And they're highly unlikely to meet in the second half of an even-numbered year, and they're running for re-election. So again, my prediction is that this convention, if it is approved, will take place either in the fall of 2023 or more likely 2025. The campaign for delegates. It was, again, expressly nonpartisan, and virtually all of the candidates were running on some platform of looking towards statehood. You obviously had some contentious views on issues, but people pretty much were focused on one thing, which was to provide a document that would prove to Congress, to the people of Alaska, and to the country that Alaska was mature enough to be a state. That motivation is not going to be the predominant one. My guess is that we're going to see candidates that were going to be championing specific changes to the Constitution or causes. And I also suspect that these issues may drive a lot of outside money into Alaska. As I mentioned before, the last convention we've seen was held under this methodology was Rhode Island in 1986. So it's been 35 years since we've had this kind of environment anywhere in the country. Alaska's a perfect test tube for it. We've seen the kind of controversy over ranked choice voting and the national attention that experiment has had. I suggest that a convention provides all the greater opportunity for people who want to refashion, re-engineer state government, that Alaska will be a great place for exactly that to take place. There's the cost of the convention, and this number, bottom line, is roughly $17 million, is an estimate that was put together for Senator Gary Stevens' staff in September of last year. It's, I would say, in the big scale of things, not a lot of money when you're talking about an issue as weighty as a convention. The real cost is the uncertainty that's created both in the time between passage and ultimately what is ever presented to the public, and not knowing what the ground rules are going to be. And then afterwards, to the extent that there are major changes, recognizing that it may be years or decades of litigation over what specific terms are in the convention. So I highlight here what I consider to be the major risks. Pandora's box is the term that we've used. It's just the outcomes are incredibly unpredictable, and everyone is at risk. It will cause a great deal of polarization in the state, and then I highlight here, the fact is we have a system that works, and that is making use of the amendment process in front of the legislature. The legislature has put 42 different proposed amendments before the public over the course of our statehood. 28 of them have been adopted by the people, and it's proven to work. I'm going to stop here. I've got more stuff here, but I think this is probably a good point to stop and deal with questions.
Well, thank you. Thank you very much. Do we have any questions from the audience?
Yeah, thank you. So I've been on the, thank you for this presentation. It's addressed a lot of issues that I've had in my mind here the last month or two. You know, I'm on the fence on this issue. For me, the issue is justice. I see a massive failure of our criminal justice system in this state. And I think that a lot of it has to do with how we elect our judges, or the fact that we don't. I'm concerned about the power that the Alaska Bar Association has. So I get what you're saying about opening up the Pandora's box here, but especially, you know, in this place where Alaska Natives, the prison population is double what the regular population is, and a lot of Alaska Natives are not able to get justice in this centralized system that we have. So how do we, you know, and I've brought these issues to both the House and the Senate this last winter, and so I don't see this legislative route as an alternative, because I presented them with facts of injustice, of wrongful convictions, and they completely overlooked it. So in your estimation, how do we go about bringing justice to Alaska Natives in this situation? Thank you.
Well, let me ask a different question to you. First of all, I would respond, yeah, I think there's been a lot of injustice. I think the court system has, over the years, tried to look at improvements both in terms of its sentencing guidelines. They've looked, again, at who's being incarcerated. I would say from initial tentative steps, there's been greater and greater embracing of tribal courts, which stand as independent bodies. But so I see some movement to try and address the issue generally. But I guess my question to you would be, what constitutional fix do you think changes that? You've alluded to elected judges. And again, the topic was one debated extensively at the convention itself, but overwhelmingly rejected. And primarily because of concern about politicizing the judiciary. And So I guess my question to you is, what constitutional fix you think would move us more in terms of our concept of justice?
Well, it's not a simple process, right? Because there's not only the judiciary, but there's also prosecutors.
Sure.
And there's also law enforcement. I think we're the only state in the country that doesn't elect judges, prosecutors, and sheriffs. And we have this centralized law enforcement. You know, I think that, you know, one of the problems is our judges don't enforce the Constitution. There was a 1972 case called Alvarado. I believe, I forget the judge who wrote that opinion, but it said that, you know, when there's an alleged crime in a village, and the defendant is from that village, the jury is supposed to be representative of that village. And, you know, I think we had judges back in 1972 that, you know, honored that. It's a very well-written opinion, Alvarado. But, you know, what's got me going here the last 3 years is a case over in Juneau, where, you know, the guy was brought over here, and all Alaska Natives, 2 trials. All Alaska Natives were excused from his trial. He was not tried by a jury of his peers. And that was defended all the way up to the Supreme Court. And there's other cases where judges are not following the Constitution. I mean, you know, a grand jury is supposed to be presented with exonerating evidence. There was admissions in that case that he was innocent, and those were buried. And let me just finish. There's this thing here where
I'm going to cut you off only because I'm willing to have this discussion with you, but I want to make sure if there are other questions that I have a chance to deal with them as well.
Thank you.
I've got a question about the issue of outside funding. And I was just wondering if you had figures that could compare existing elections, recent elections of state officials and officials to the U.S. Congress regarding how much outside funding came in, and might be useful as a comparative tool to think about that question.
It's a good question I don't have the answer to.
I was just curious, you mentioned, you know, a lot of the dissatisfaction with government and, you know, kind of lack of awareness of, you know, for especially young people, you know, young people not being civically engaged. And I was curious if you had any encouragement for young people to become more civically engaged and understand these issues so they can be educated voters.
I think that is one of the perennial questions in terms of how does one engage young people, and partly, and it's triggered, I think, in part by your comments as well. How do people build confidence in their government, or build confidence in the view that they can make changes or they can influence changes? I have to say that I'm incredibly heartened by the results of the special general election we held, because I think it in itself is some proof that there is room, much room, for people who traditionally are not heard to have their voices heard and to make a difference. And to me, that's the ultimate test. I personally clearly encourage young people to follow what their government is doing, feel willing to actually speak out. It doesn't have to start with the legislature. It starts with being able to be active in front of local boards, being willing to address the assembly, the school board, Parks and Rec, or whatever. But and to make use of civic organizations that will help people develop the skills, speaking skills, to the extent necessary, perhaps the parliamentary skills that will serve well in trying to fashion government. Again, particularly being in this place, I think of the role that A and B and A and S historically played and continue to play in developing people who were thoroughly familiar with parliamentary procedure, understood how government works, and made a calculated commitment to involve themselves in the system. I think that's the kind of commitment people need to make. And I do this not in a sense of these are platitudes. I think it's just a matter of becoming engaged and finding some small experience that shows that you can move the needle. And I think there are opportunities if one looks for them. Hope that's helpful.
Thank you.
Well, thank you, Mr. Mayor, for your presentation. I have to tell you that I attended the Constitutional Convention in Fairbanks. I was just 10.
Youngest delegate.
I did attend it, and I actually did a study. Along with Dr. Puller, Dr. Brennig, and myself, did a study on the Statehood Act and the Constitution. And I used my quote that I had written there when I attended the Constitutional Convention. And it really showed me as a young, naive young lady, very optimistic about the future. But I was very happy, about the Constitutional Convention. And I didn't understand all of the things that were happening, but I do remember, Frank Peradovich and I think Marsden, talking about resolving the Aboriginal claims for Native people, our Aboriginal land claims. And our study actually, recommended a constitutional convention with the objective of recognizing tribes and recognizing subsistence rights of Native people. However, I have to say that since studying, more about this the proposal for a constitutional convention, and then when I saw I guess it's Yes Constitution, I saw their proposed constitution, we became very alarmed. We in the Native community became very alarmed. And I think a number of organizations such as Sealaska Corporation, First Alaskans Institute have taken positions against the Constitutional Convention. But I think that there are issues, as the gentleman raised, that do need to be resolved. And we're keenly aware, that 41% of the incarcerated population are Alaska Natives. 41% of the current incarcerated population are Alaska Natives. So that's a great concern for us. But I'm wondering, what you're thinking about, well, I guess I also have to say that I was also involved in when the Judicial Council did a study, and they found out that Alaska Natives were receiving sentences that were twice as long as non-Native people. And the Judicial Council or the legislature created a minority sentencing guideline committee. And apparently, we don't know if it's worked. I mean, there was a subsequent study that said it worked, but it only examined one part, and that was looking at the judges. And I remember we had orientations for judges, and I made presentations and talked about the difference between discrimination and racism. But we never expected that was going to solve the problem. But the question is, do you think that tribal courts, could we, under the recent legislation that was passed, HB 123, could the state now support tribal courts under this law, and would that begin to address, I think it would, I guess, but I'm wondering how you feel. Would it address some of the problems that have been identified?
I would say absolutely yes. I mean, that's a direction I think we're evolving to. What I can't say at this point is the extent to which the legislature is prepared to embrace through legislation. We have the federal legislation now, but I think there are more steps to be taken. I think the court system, the judiciary, seems to be much more receptive. But this has been true, I think, for the last 2 decades at least. The judiciary has been farther ahead than the executive and legislative branches in dealing with the role of tribal courts. I'll also go on to say that if there is a convention, I have a laundry list of things I'd like to see changed as well, and you've hit on a couple of them, and that is the failure to acknowledge the role of tribes, Alaska's indigenous peoples. Clearly, subsistence has been a hot topic for decades, ever since 1989, and would be one to address. The 55 Convention, of course, ducked the issue of land claims. They basically incorporated language that was appearing in federal legislation as conditions for statehood, among others, surrendering any claim to Aboriginal lands. But the convention itself debated the issue, as you pointed out. Delegate Marston had actually proposed 10 million acres of territorial, or what would be state land, to be set aside. And I would say it was rejected by, I think, 53 of the 55 delegates, but for various reasons. Some believed that it would leave let the federal government off the hook for its obligations. But I think an underlying current was also a racist. We don't think Alaska Natives should get anything that anybody else couldn't be entitled to. That was the tenor of the time. And it's also worth noting, kind of a footnote, there was only one Alaska Native out of the 55 delegates, and Rosita mentioned him, Frank Paratovich, who from Klawock, who been Grand President of A&B at the time. And you contrast that with Hawaii, which had 63 delegates. 29 of them were white. I think 19 were Japanese origin. 11 were Hawaiian or part Hawaiian, and 5 of Chinese descent. And so it represented a much broader, more diverse convention than this territory saw. And again, reflecting, I think, the times, unfortunately. Any other questions? I think I'm probably at time. I'm willing to continue to stay here as long as people have questions. But
We're right up on the 1 o'clock hour. I guess my only encouragement is to get out and vote on November 8th or before.
That's great.
Extra closing comments?
I think, thank you all for your attention. It's been a delight to talk with you.
Thank you. Thank you, Bruce. Thanks for sharing some excellent information with us. Our next lecture will be this Thursday, and it will be Une Lance Twitchell presenting on his language revitalization work. So please join us at 12 o'clock on Thursday.